family. This is Dayvon Love, Director of Public Policy, Leaders of a Beautiful Struggle. This is another episode of Streets to the Statehouse. We are in the 2025 Maryland General Assembly. This is February 11th. And so we're still in the beginning of session, but we're in a moment where, there's an increased level of awareness and really settledness around certain policies that are going to be major parts of the legislative discussion and activity during this Maryland General Assembly. So really this particular episode is going to be largely just legislative updates on aspects of our legislative agenda and other legislative items that we're also paying attention to. And so that's largely what I'm going to do this evening. What I'm also going to do, though, is take a couple of pieces of legislation that I've testified on and use it to talk about kind of a major dynamic I think runs across many of the major legislative items that we're gonna talk about tonight and talk about really throughout session. So before I get into that, I want to remind everybody, and for those who aren't familiar, Leaders of a Beautiful Struggle, we're a grassroots political think tank, advocate unapologetically for Black people, revolutionary Pan-African nationalists. Our perspective is that the importance of Black sovereignty is a basis for our ability to be a political force. And so much of the dialogue and discourse you're going to hear tonight, we have the ability to give an analysis of the legislative landscape from an unapologetically Black lens and perspective as a result of our political independence. And so a lot of the commentary that you're going to hear, we think we provide a unique perspective that allows us to really talk explicitly about some of the dynamics that are happening in the Maryland General Assembly, especially given one of the underlying theories that we operate from is that we live in a society structured on racism and white supremacy. No different than in the Maryland General Assembly and the dynamics as to how white supremacy operates. So one general big picture framing thing that I want to get into before getting into the legislative updates. A big part, and a large part of what has been our legislative agenda in the Maryland General Assembly has related to issues of criminal justice. And, a big part of the reason for that is that the criminal justice system, has been weaponized against people of African descent really throughout the history of this country. There's a way that notions of inherent criminality and the notion that Black people are inherently prone to violence that have been weaponized politically against Black people as a way to advance a right-wing conservative political agenda that reinscribes the nature of white supremacy in the society. And so when we talk about mass incarceration in the prison industrial complex and police brutality, like all of these different systems have been weaponized against our community. And there's a way that the weaponization of the criminal justice system, law enforcement, just the regime of prisons and punishment in the Western Hemisphere, particularly in the United States, there's a way that weaponization has been normalized. And there's certain kinds of suffering that people of African descent deal with on a day-to-day basis, particularly working class Black folks, that is rendered normalized. And by being normalized, it is rendered invisible. So many of the issues that we're going to raise in terms of having to do with the criminal justice system, largely because this is a system that, again, has been weaponized against Black people for political purposes. And again, I'm going to talk more about that as we talk about some of the individual issues. I'm going to start with one of the major issues that we have worked on, over the past couple of sessions around issues of juvenile justice. I'm going to talk about two issues kind of in one. So one is an update. So one of the things that is on LBS's legislative agenda is ending the practice of automatically charging youth as adults. There are about 30 charges or so that if a young person is charged with any of those charges, they are automatically put into the adult system. And in the adult system, putting young people in the adult system is dehumanizing. If you think about, the fact that in the adult system, young people are not entitled to education, they're not entitled to mental health services, and there's just much less protections in the system, in the adult system, there are in the juvenile justice system. And just imagine what it would be like for a kid to be in an adult prison. And as we mentioned on previous podcasts, and in previous, public statements on the issue, that in many respects, because the policy is supposed to be that young people are sight and sound away from adults in the adult prison facilities, which in many respects is functionally like solitary confinement, which again is extremely dehumanizing for a person to be, for anybody, much less a kid, to be in the adult prison system. So this has been a practice that Maryland has engaged in for decades, and there's been a over a decade long effort to try to end the practice of automatically charging youth as adults. The policy that LBS supports is that all young people should start in the juvenile justice system with the ability for a prosecutor to waive that young person up to the adult system if they deem it necessary. And in fact, 75% of young people that are in the adult prison system end up getting waived back down anyway, right? So that's just kind of the general information about that issue. Again, if you listen to previous podcasts on legislative agenda and other things that we put out, we'll talk more in depth about the specifics of the policy. Where we ended up, because we wanted a bill that would eliminate the practice in its entirety, what we were able to get in this General Assembly is the Legislative Black Caucus of Maryland supporting a bill in the Senate. It is Senate Bill 422, which is sponsored by the chair of the Judicial Proceedings Committee, Senator Will Smith out of Montgomery County. And its cross-file in the House is House Bill 1433. Delegate Karen Tolles is a sponsor in the House. This is a bill that is a part of the Legislative Black Caucus legislative priorities for this session. And again, want to thank the Black Caucus for stepping up to make this one of their legislative priorities. And so what was put in was a version that reduced the amount of charges that would automatically charge a young person as an adult. And according to the Department of Juvenile Services, would account for 73% of the young people that are in the adult prison system. Again, this bill was sponsored. So there was a hearing that happened last week in the Senate Judicial Proceedings Committee, where I testified and many other advocates testified in support of that piece of legislation. Much of the resistance to it is similar to many of the other arguments that are made by the law enforcement establishment against these kinds of measures, which is that they want to ensure that young people that commit heinous crimes are subject to the adult prison system. Of course, our argument being that they can waive, there's ability to waive young people up if they belong in the adult prison system. One of the things that I want to highlight, because you've heard us talk about David Smith, who's the executive chairman of Sinclair Broadcasting and Fox 45's coverage of juvenile crime over the past several years. And one of the things that is important to note is that what Sinclair Broadcasting does, and other media outlets, WBAL, WBAL Radio, and others, will circulate the same stories of extreme instances of young people engaged in crime and brutality, play it over and over and over again. And then that becomes then the rationale and justification for wanting to maintain this practice of automatic charging of youth as adults. And that is essentially what played itself out during the hearing on this bill, where Scott Schellenberger, who is the state's attorney of Baltimore County and has been a major force in the policymaking space in Annapolis for decades at this point, in his testimony gave several extreme examples of violence committed by young people as the kind of engine, as the fuel for the engine around his support to maintain the practice of automatically charging youth as adults. So if you go back and watch the testimony, the opposition testimony, you will hear Schellenberger just give those same extreme examples. And I wanted to highlight that because that is what we will get, is we will continue to get in terms of the opposition, the discourse around the opposition. You're going to hear people talk about the extreme examples. And part of the impact, as I mentioned to you before, 75% of young people that are in the adult system get weighed back down anyway. So the argument of using those extreme examples to justify maintaining the policy puts the 75% of young people that end up being in the adult system that get weighed back down anyway, that the dehumanization they experience as a result of being in the adult system becomes collateral damage, right? If we're using the logic of the opposition, that because of those extreme examples that they gin up to essentially activate existing societal beliefs around notions of inherent Black criminality, then it becomes the justification for maintaining a policy that subjects young people to an adult prison system that, again, many of them end up getting weighed back down anyway. So that bill was heard in the Senate. There's a House hearing for that bill in a couple of weeks. We'll post on our social media and in our communications, we'll post when the hearing for that on the House side is. One of the things that we put out an action alert to urge last week to urge people to reach out, particularly to Senate President Bill Ferguson and Chairman of the Judicial Proceedings Committee, Will Smith, who is the sponsor, to urge both of them to put the bill up for a vote, right? And to reach out to each of the members of the Judicial Proceedings Committee in the Senate to urge all of them a favorable vote on Senate Bill 422. So over the next few weeks, we're going to be putting a lot of effort and energy into urging the Senate president and political leadership to put this bill up for a vote. It's clear, based on some of the public pronouncements of Senate President Ferguson, that he's not interested in touching the issue at all, right? So we're clear that there isn't an appetite for it from the Senate president's office. And so that's why we want to just emphasize and encourage people to reach out to his office, to pressure him to at least let the bill be put up for a vote, right? Let's put the bill up for a vote. Let's see what the committee says. And then if you all reach out to the committee to force a favorable vote, that puts us in a better position to move the bill out of the Senate, and then allows us to start working over in the House to see if we can move the bill in the House. So that's where we're on where we are on that. Stay tuned for that. And then related, one of the things that's in our legislative agenda is protecting the Child Interrogation Protection Act. So as many of you out there are familiar with this podcast, remember, we were a part of an effort to pass legislation that simply says that if a police officer engages in a custodial interrogation of a young person, that their parent is notified, and that that the young person consults with an attorney before they participate in a custodial interrogation. So that's all the bill says. Law enforcement has continually characterized the Child Interrogation Protection Act as an impediment to being able to talk to young people to solve crimes. I'm going to talk about why that's ridiculous in a moment. But Senate Bill 531, whose sponsor is Senator Folden from Frederick County. I'm going to talk more about Senator Folden later on. But he was the sponsor of a bill that essentially will remove the requirement for a young person to consult with an attorney before engaging in custodial interrogation. And the rationale for this being, again, from law enforcement, that this takes away a tool that law enforcement feels it needs to solve crimes. Now, here's a few reasons as to why those claims are ridiculous. And I want to note that we're talking about very fundamental protections, right? Given the fact that, young people are 3 times more likely to give false confession. We know about the way in which, as we talked about in the previous piece of legislation I mentioned, young people, Black youth make up 80% of those youth charged as adults. They make up an overwhelming majority of the young people that are in the juvenile justice system. So young people have disproportionate contact with law enforcement, disproportionate contact with the criminal justice system. And so there should be protections, given what we know about the nature of law enforcement interaction with Black youth. It should be a no-brainer to support policies that would provide that level of basic protection of young Black folks that are subject, based on empirical data at this point. So we're not talking about conjecture, we're not talking about just people's feelings. Basic protections for a phenomena that we know is experienced by Black youth. And so a few reasons why the claim that this impacts crime fighting is ridiculous. The first, law enforcement continues to say that they can't talk to young people. That is untrue. They can have a conversation with a young person. Young person's outside doing something. They can ask them where they're going, what they're doing. when you take know your rights trainings, one of the things that you're often told is that in order to see if you're being detained, one of the things you ask is, am I free to leave? And if you are not free to leave, that's when you could mark the beginning of a custodial interrogation. Now, there's some subjectivity to that, from a legal liability perspective, but that is generally in know your rights training. That's what you're told, right? So we're only talking about custodial interrogations. We're not talking about just talking to young people in general. So law enforcement officers, when they say they're not able to even talk to youth, that is just incorrect. It is if you read the language in the legislation, it's a custodial interrogation, right? And I think the overstating of the limitations in terms of talking to young people is a propaganda tactic. It is a propaganda tactic because unfortunately, law enforcement, in terms of how many of them have been taught and trained to carry out their duties, require these shortcuts, right, in ways that in this context wouldn't make sense for an adult. An adult is not entitled. The adult doesn't have to say anything to a law enforcement. They have the right to remain silent. So for a young person, that protection should remain, and there should be additional protections in order to ensure, as a vulnerable population, given the data about young people's contact with the criminal justice system, that extra protection, we think, is important. Secondly, one of the challenges is that, or not a challenge, but one of the things that is in the bill, because again, they'll use extreme stories. The Harford County Sheriff, about a few months ago, with the Joppatown shooting, talked about child interrogations as an impediment to being able to talk to the young person who possessed a firearm. What is important for people to know, as a person who was in the Senate Judicial Proceedings Committee as the committee was working on the language that ended up in the bill, there is a public safety exception that if an officer perceives an imminent public safety threat, right, that it is an exception in terms of the ability to engage in a custodial interrogation, right? This is what is in the bill. So folks like the Harford County Sheriff, and again, I'm gonna talk about him again later, when he goes out and says that he can't talk to young people and gives that extreme example, right, of the incident that happened in Joppatown as a rationale for why the legislation is problematic, there's a public safety exception, right, that circumvents that. So again, what this bill, SB 531, would do, sponsored by Senator Folden, was that it would remove the requirement for a young person to have to consult with an attorney before engaging in a custodial interrogation. So that is a bill. And of course, one of the things that it's talked about as, lastly, is it becomes another tool for crime fighting that law enforcement doesn't have anymore, right, as a result of the Child Interrogation Protection Act. And I would argue that law enforcement needs to substantiate that claim with some evidence. Like, I've heard anecdotal, like in some anecdotal examples. I think that the law enforcement establishment, outside of the handful of extreme examples that Schellenberg is going to think of, they should be required to give a thorough, systematic explanation as to, given what is the facts about the Child Interrogation Protection Act, explain how this is a hindrance to crime fighting in a way that we should deem legitimate. So that's a challenge that I would issue to the law enforcement establishment. So that is a bill that we're going to be paying attention to. So I'm going to talk a little bit more about some other criminal justice related policies that we're looking at that aren't necessarily on our agenda, but things that we're paying attention to. One of those bills is good cause expungement. It is the sponsor in the House. It's House Bill 55, sponsored by Malcolm Ruff. And this is a piece of legislation that essentially would, because what we have, so let's talk about expungement in general. The Maryland General Assembly over several years has put forward and has passed legislation regarding expungement in a variety of different areas. And the policy around expungement can be rather complex, right? If you look at the criminal code and you look at, you know, the conversation about what should be expungible, what's the procedure, it can be fairly complex. And there have been attempts at dealing with certain areas of law, right? Certain areas of criminal charges, criminal convictions, and charges, that would be expunged from the record. What this bill, House Bill 55, does is make the process a bit simpler, where it would just allow an individual to go before a judge and a judge make an assessment as to whether that person's record should be expunged. Because we're clear that a part of why expungement is important, given the heightened level of contact that Black people have with both law enforcement and the criminal justice system, convictions and certainly charges are not indications necessarily that a person committed the crime. Oftentimes, the tagline of what a crime says does not always match up with the story behind it, right? So if a person, for instance, did some time for aggravated assault, and it turns out that a part of the story was it was a fight that happened in self-defense, right? A judge should be able to look at the facts of the case, see that a person has done their time, and be able to make an assessment and say, this person shouldn't have this on their record, because what we know is that, and this is something that, again, disproportionately impacts Black folks, that if you have a criminal record, it becomes a barrier to employment, right? It makes one at least less competitive for employment, right? And certainly evokes many of the stigmas. You think about like a criminal record, you think about the fact that we live in a society where we're conditioned to see Black folks as inherently prone to criminality. And so even if you just have a charge, like one of the things that's been hard to pass, for instance, is automatic expungement for non-conviction. So things that you weren't convicted for, right? That's something that's been hard for this legislature to pass, right? And merely having a charge, not even a conviction, but having a charge, right? That can be a deterrent, particularly for Black folks, as it relates to being able to get access to employment. So good cause expungement cuts through the complicated nature of all of the criminal code and just allows a motion to a judge for a judge to make an assessment based on that individual person's case and circumstances to make the determination as to whether that record should be expunged. So that's another example of a piece of legislation that we're following that relates to criminal justice. What I'm going to do now is I'm going to talk about our work on reparations in the legislature, and then I'm going to pivot back to more of the criminal justice related work and use it to talk about just general framing around the discourse around criminal justice in the legislature. So as many of you know, reparations has been a big part of LBS's legislative work over the past several years. We focused on using the legalization of recreational cannabis as the basis for reparations for the war on drugs. And so we were able to get the legislature to establish Community Repair and Reinvestment Fund. And that turned, and on the Baltimore City level, the Baltimore Reinvestment and Reparations Commission. And so that work we've talked about in previous podcasts. I won't go too in depth of that, but reparations has been a big part of our work. We believe that if we were able to successfully move the legislature to implement a policy that was an attempt to repair harm that was done by the war on drugs, the legislature then should be able to do that beyond just that. And so in conjunction with work with the Legislative Black Caucus, the Black Caucus, as a part of their legislative priorities for 2025, have put on a bill, and that bill is SB 587 and House Bill 1422, that would establish a commission that would study reparations in Maryland and would deliver to the legislature in 2027 a series of recommendations for how the state should redress the way that the dehumanization that occurred against Black folks in Maryland should be repaired. So that's the bill. And actually the hearing on that, again, we'll post that in our social media. The hearings in the Senate and House version will be in a couple of weeks. in the House, the senator, or in the House delegate, Alethea McCaskill, who I want to thank for all the work that she put into trying to spearhead this effort, the work that she put in to include some of the things that LBS wanted to see in a reparations bill. I mean, anyone who's familiar with our work on reparations and what we said on this issue, we believe that there's enough information to put together a reparations package and to really circumvent a study. But we understand the importance of wanting to establish a study so that the state can have on the record from a source that it sanctions what those remedies should be. And we're appreciative for the work that Delegate McCaskill has put into getting us to the point where we now have a bill. And there are a variety of folks who have put in reparations bills, over the past several legislative sessions, which includes folks like Delegate Gabriel Acevedo, who's put in legislation in the past, Delegate Marlon Ampry, who's also put in a study bill in the past. And so there are a lot of folks who have worked on this issue in the legislature to get it to the point where now the Legislative Black Caucus is now putting forward a bill that will establish this commission to study the issue of reparations. So again, just want to just give a big shout out to Delegate McCaskill. And then on the Senate side, the Senate sponsor being Senator Muse out of Prince George's County. Again, we'll put up information on our social media as it relates to when those hearings will be. All right, so now I want to pivot to two other additional issues that again are not on LBS's legislative agenda, but are issues that we're watching and things that we think are important for people to pay attention to. And I'm going to start with a bill that I was asked to testify on. I'm actually going to be testifying tomorrow in the House on this bill. It's Senate Bill 292, House Bill 635. This is a bill that would essentially change the categorization of what kinds of offenses that police officers can pull someone over for, right? So it would, things like an obstructed view, your mirror view being obstructed, things like your illumination of your license plate, things like having a headlight out, those are the kind of things that will be secondary offenses that you can get a citation for, but cannot be the pretext for why an officer pulls you over. And the rationale for this bill is to reduce the amount of traffic stops, therefore reducing the contact that Black folks have with law enforcement. Black people are disproportionately pulled over by law enforcement. So for instance, in Maryland, though Black folks are about 32% of the population, well, 43% of those who were pulled over. In places like Harford County, where Black folks are 16% of the population, over 40% of those that are pulled over. So the bill is an attempt to address the fact that, Black folks are more likely to be pulled over and therefore more likely to have negative interactions with law enforcement, which run the gamut between inconvenience and disrespect to abuse and brutality and everything in between. And one of the things that I want to highlight, because I think this is, in terms of the issue itself, it's a fairly simple issue. The solution requires some work in terms of how to operationalize, and that'll be some of the discussion tomorrow. But the basic concept is pretty straightforward. One of the things that I want to call people's attention to was a video that was put out a few weeks ago by the sheriff of Harford County. And I want to highlight that it was a parody video that essentially made fun of this bill. And so you can go check it out. You search Harford County traffic stop bill, you'll be able to find it. It is an example of the way that the suffering that Black folks face is trivialized. And it goes back to one of the things that I said in the beginning, that to me is an underlying dynamic in much of the policy that we talk about as it relates to criminal juvenile justice, which is that when you talk about the kinds of abuses that particularly working class Black people face, there's a way that it's normalized. And for me, this parody video is an example of the trivialization that this society has with the nature of the kinds of impact that these systems have on our community. And I think, I think, it is ridiculous that that a sheriff of a major jurisdiction would stoop that low to do that kind of parody of something that for Black folks is very serious. I want to really lift up Senator Charles Sidnor, who is the sponsor in the Senate, I'm appreciative that he took up the fight to put this bill on the table to address this issue. And unfortunately, as a result of this video that was put out by the sheriff of Harford County, has gotten a lot of very nasty, racist, vile comments, both in terms of emails and comments on his social media as a result of this parody video, which demonstrates the kind of consciousness we're dealing with. We're dealing with folks for whom, again, have no regard for the impacts that that our disproportionate contact with law enforcement have on our community, right? So just wanted to point that out. And then additionally, one of the things I want to say on this issue, in listening to the questioning from Senator Bill Folden, so I mentioned him earlier as the sponsor of the bill that essentially would roll back the Child Interrogation Protection Act. I want to talk about Folden's line of questioning, Senator Folden's line of questioning to Senator Sidnor, right, and to his panel, because I think his line of questioning is the underlying rationale for much of the opposition. And I'm actually very glad that he said what he said on the record. So what I'm gonna do is I'm gonna paraphrase some of what he raised as his issue with the bill and then respond. So a few things. One is that he characterized the bill as an example of another anti-police measure, right? So he talks in a very exasperated tone that this is another example of painting with a broad brush law enforcement officers being bad. And he talks about uses the same kind of, there are a few bad apples, and that shouldn't be used to paint a broad brush in terms of police officers, and that this bill is another example of characterizing law enforcement as, inherently bad people. So that was the first part of what he said. The other thing that I want to highlight is to what he says is that because he was frustrated at the way that race is described as a key feature in the issue of traffic stops, right? And he felt like bringing up the notion of race makes it so that he can't say the things that he thinks are legitimate justifications for opposing the policy. And what he lays out from his perspective as a legitimate thing to raise is that he says that if you look at those jurisdictions where traffic stops recovered firearms, right? Baltimore City having the most, Prince George's County being second, Baltimore County being third. And what he said without saying it, and this part that I'm about to say is a legitimate observation, which is that the areas that experience the most contact with law enforcement are the same areas that are plagued by violence, and that those communities also tend to be Blacker in terms of the demographic population, right? Now, that is something that many people might be afraid to say because it sounds racist. And I don't think that the observation itself is not a racist observation, right? And so I'm actually glad that he was as explicit as he was, because I think, unfortunately, other folks that take his position aren't nearly as explicit, right? So that is the point that he's making, is that if law enforcement is going by the places where they seize firearms, right, from traffic stops, and they happen to be those same communities that tend to be over-policed, then that should be a rationale that wouldn't reduce it to racism, but should be reduced to doing their job, right? That in essence, in many ways, is the best version of the point that I think he's making. Here is the problem with that perspective. There's several problems with it. The first is that when we think about violence, and one of the things I've said in many different contexts, law enforcement should not be the central force in terms of dealing with violence in our communities. That when we think about violence, often the conversation around how the notion of racism and white supremacy impacts it doesn't come up. Because what people think is black people killing black people. So why are we talking about race? In fact, anybody who's done a rigorous study of the dynamics that contribute to violence, and again, it's a quote that people have heard me use on several occasions, paraphrasing of something that Amos Wilson says in his book, Black on Black Violence, that when we talk about homicide and the prevalence of it in majority black communities, particularly urban settings, it is an externalization of a suicidal impulse. That when you live in a society that tells you you're inherently criminal, that tells you you're worthless, it is easy to kill someone that looks like you. And that is the societal propaganda that black folks, particularly in this context, black men, are the biggest perpetrators and victims of violent crime. That reality is the best explanation for the nature of violence that happens in our community. It is not an issue that as some people might put it, and I think this is where conservatives, are embracing a racist belief. It is not the case that it's an issue of these are just people who, the culture of poverty argument, that these people are misbehaving because they have lesser morals and they're not getting the punishment they need to be more morally righteous, right? That's not the problem, right? The problem is that when you live in a society that tells you you're worthless, and that many of the institutions that are tasked with socializing our young people reinscribe those feelings of worthlessness, reinscribe those feelings, that those notions of inherent criminality, being prone to violence, right? Then that is what produces much of the violence that we see. And so as I mentioned a few moments ago, law enforcement is not going to be the basis of reductions in violence in the community. And in fact, Baltimore City, in many respects, is a good example of that. That, as LBS has argued, and many others have argued, you see how We Are Us, right? It is community-based, grassroots, Black-led organizations who are able to talk to those communities that many folks in law enforcement and many of us, just regular folks, don't have the credibility to go into those communities and engage folks that are engaged in the behaviors that we're talking about, right? So it is those community-based grassroots organizations going into the community, engaging people, interrupting violence, right? In terms of violence interrupters, right? Helping relocate people, helping to adjudicate conflicts. That is going to be the best way to reduce violence, not law enforcement. Law enforcement ideally should be the last resort, right? So that's one issue with Folden's perspective, is that law enforcement should not and will not be the focal point of what it takes to reduce violence, and Baltimore City is a key example of that. Secondly, the mere presence of a gun does not indicate criminality. So what Folden says, and we dealt with this a few years ago and pushing to pass a bill that would make it so that law enforcement can't use the odor of cannabis, being that it's legal, as pretext for stop and search. And one of the arguments that was made against that bill was that it impaired their ability to seize firearms. And they talked, and particularly the Montgomery County State's Attorney McCarthy would talk about how it was such an important tool for seizing firearms. The presence of a firearm is not necessarily an indicator of criminality. This goes to the notion. So it's one thing to say you seize the gun, but until there is data connected to it that says that this person with the gun, that this number of people whose firearms were seized are connected to, organized crime or other instances of violent crime, unless that part is included in the explanation, the mere seizure of a firearm does not indicate criminality. This goes to the argument we make about the way that white supremacy conditions our collective consciousness. That when we think about the fact that for many Black folks that live in communities where other people have firearms and more firearms available than any other time in the world. So if people live in communities where folks have access to firearms, the decision to carry one is a rational decision. But because of the societal propaganda that sees Black folks inherently prone to criminality, one can just say, oh, seizing firearms is a crime fighting tool, when in actuality, again, the mere presence of a firearm is not indicative of violent crime. And that many of you who are listening to this probably know people that carry firearms who aren't bad people, who aren't trying to, cause violence, but have one for protection. So again, Senator Folden's point to say that they seize firearms using these pretextual stops does not, you have to connect more dots to get it to a place where it's demonstrating actual public safety value, right? So that's important. And then additionally, again, to refute Senator Folden's point is that one of the things that is often not looked at when these conversations happen is when you're looking at homicides, right, and non-fatal shootings, what are the circumstances around those homicides? Because part of the way that Hollywood and popular culture has gotten into our consciousness, as you think about the stereotypical bad guys that are engaged in organized criminal activity, or people who are just inherently bad people that need to be put away. And anyone who lives in the world recognizes as Hollywood that the world is more complicated than that. And that when you ask for information, now this is information that's hard to find, like an analysis of the type that I'm about to describe is typically difficult to find. But the best example of this data that I have found in recent time was actually some data that originates from Baltimore City's Mayor's Office of Neighborhood Safety and Engagement, where they looked at the Western District, which at the time was one of the most violent districts in the city, police districts in the city. And so what they noticed, they did an analysis of what were the causes of those homicides in the Western District. And what they found was that, because I think one of the notions that often people associate with homicides is drug trafficking, right? People engage in violence as a result of drug trafficking, the drug dealer trope, right? And it's easier and simpler to just think that these bad guys selling drugs and doing bad things, and we define them. Well, what that data found, it was 2 years of data that found that drug trafficking was like third or fourth, right? That the top category of causes of homicides were interpersonal disputes, group disputes that went bad, right? And then you start getting into things like drug trafficking. I'm mentioning all of this because if we're using the top one, which I remember certainly was personal disputes, and I think that accounted for about a third of the homicides in the Western District at that time. If that is the largest category, then the idea of seizing firearms for people that are, from folks that in traffic, that what's important to keep in mind here is that those personal disputes, right, are not stopped by this practice of stopping people on the side of the road, right? Many of the typical traditional approaches to crime fighting that are so focused on the drug dealer trope to the organized crime trope. But if large numbers of the homicides that happen are not the result of organized crime, right, and have more to do, again, with interpersonal disputes, right, or group disputes, then the presence of a firearm does not change the nature of those disputes. And that this goes back to the point that I made a few moments ago, which is that those community-based violence prevention organizations and engaging people to prevent those disputes from turning violent. to prevent those group disputes from turning into violent activity. That that those are the best ways to deal with violence. So I'm saying this again in response to Senator Folding's claim, because the notion that this is taking away that the reducing the number of pretextual stops that officers can use to pull someone over as a crime fighting tool isn't connected to data that would help to substantiate why this would actually stop the violence that is currently happening, especially given the fact that, again, violent crime is going down as a result of community-based violence prevention. So I'm saying again, for me, it was important to refute what Senator Folding was saying in his response to Senator Sidnor on this bill, because I actually think that this logic underlies much of the resistance that folks have to many of the policies that we've mentioned before. So again, that's something that I'll be testifying on Wednesday the 12th in the legislature. And then the last thing by way of legislative update, and I want to use this to expand on some of what I just talked about in terms of responding to Folding, but just in terms of bigger picture, advocacy around criminal justice and how, again, notions of criminality impact the policymaking landscape. So the Afro-American newspaper, shout out to them for, being helpful in allowing us to publish much of our commentary for the public to see. Recently published an op-ed that I wrote called "Whose Pain Matters," and in that op-ed, I actually focus on the second look at, which is a bill that would allow for a person who has served at least 20 years to have a motion put in to have a judge review their sentence, to potentially modify their sentence. And the purpose of this is that for two major things. One is you have some people who were incarcerated, convicted for things where racism played a part in the court proceedings, right? And when you talk to people who reviewed some of these court proceedings, where you have people that have spent long time in jail, you look at the record, the existence of racism in the commentary and many of the procedures is evident, right? So that's one aspect of it, that people who have had harsher sentences or unjust sentences, it gives them an opportunity to have a judge look at it and to address their sentence in order to address the injustice of their conviction. And there's data that's been put out there. The U.S. Sentencing Commission report from 2017 says that Black men are usually their sentences are 20% longer than their white male counterparts, just as an example of the way of why this legislation will be important. And then secondly, those who did harm the community, who spent significant time behind bars, to provide them the opportunity to demonstrate what they've done to change their life, to be an asset to the community, and to provide a judge the opportunity to make that assessment, say this person would be an asset to the community. They've done their time and should be let out. And in fact, there's a brother, I participated in a briefing to the Legislative Black Caucus on the second look at, and one of the people on the panel is a brother, Anthony Muhammad, who is a part of We Are Us, part of our Baltimore Brothers. And one of the things that I've witnessed myself, he's a person that, did something when he was 15, spent 29 and change years, 29 years behind bars, and has come out and has been a tremendous leader in reducing violence. He's been a major force in the reduction of violence in Baltimore, along with many other organizations, many individuals. And so he's an example of someone who the Second Chance Act would allow a judge to assess a person and say they've done their time. And this is a person that would be good to have in the community to address many of these issues that other folks just don't have the capacity to go out to the community credibly and to be able to address, the community. So that's in essence what the bill would do. The reason that I thought it would be important to write something is because in watching the hearing on the Senate side, the opposition, where Black folks who were victimized by violent crime, were some of the primary folks who testified in opposition to the bill. And much of the opposition was based on the notion that their loved one was gone, right? And so any bill that would allow the possibility of a person who killed their loved one should not have any chance of being out of jail. So that was the basis of it. And so I felt the need to write this op-ed because to me, this is a central aspect of the conversation as it relates to the quote unquote public safety and criminal justice policy and what is the perceived tension between the two. Because what happens is that you have, folks who legitimately are in pain at the loss of their loved one. And those stories being weaponized in ways to characterize those of us that are pushing for these kind of reforms as not caring about those that are victimized by violent crime. So I actually want to take a few moments to really delve deep, talk about some of what I wrote about in the op-ed and delve deep into that, because I think that's an extremely important thing to tease out so that folks are clear. And one of the things that I want to say is that nobody who is advocating, whether it's the second look at, or any of the policies that I mentioned, none of the legitimate advocates for these policies believe that people that commit heinous crimes should not be held accountable. And that is often the rhetoric that the other side uses, right? That the other side used to say that we don't care about making sure that people that harm the community are held accountable. That is not true at all. And it's unfortunate that I have to start with that, but I do, because so much of the discourse characterizes these kinds of efforts as if that is the case, and that's not true, right? On this particular issue, when you think about the utilization of Black folks who have been victimized by violence, it's important for people to be clear that as I've talked about the societal conditioning on notions of inherent criminality, right, that is latent in many of our collective consciousness, what ends up happening is that those notions are heightened when we have personally experienced that kind of violence or that kind of crime, right? Like people who have had their car stolen, right? Or people who have gotten robbed, right? Or people who've been, brutally assaulted. There are ways that those legitimate feelings amplify, activate certain beliefs of Black folks being inherently prone to criminality. And what that does is that it produces then a rhetoric and a discourse that any reform to the criminal justice system is about going easy on those that are committing crime. So I want to say a few things then about that notion in terms of this idea that this is being easy on criminals. One is that it's important to be clear that given what we know about the way in which the criminal justice system is racist, the way that it's been weaponized against Black folks, that a person being convicted of a crime is not necessarily evidence or an indication that that person did what it is said they did. And I know for some people, that might sound esoteric, but to make it even more clear, right? As an example that I used earlier, right? If I got into a fight in self-defense and I was convicted of first-degree assault, right? That doesn't necessarily mean that I'm a terrible person. It doesn't necessarily mean that what I did was a statement on my morality as a person. And I think that's important because what ends up happening is that when the other side talks about convictions, they talk about people that are convicted of these horrible crimes. If we're clear about the nature of how the criminal justice system works, even if you think about plea bargains, which most cases are resolved not going to trial but by plea bargains. And in many instances, people are accepting pleas because they don't have the resources to mount what they feel like is a successful defense for them. So they plea to something because it is just situationally easier for them to deal with. And if about 90% of cases go to plea bargain, right, then it's not a trial, right, where evidence has been put out there that determines whether this person was convicted. It is, I don't want to do 25 years, and if I accept this plea, I can do 10. And I don't want to risk 25 years. Again, whether you're innocent or guilty, right? That is a bigger determining factor of a person being convicted of something, right, than them being guilty or not. Is the pressure and leverage from a plea bargain. So it's really important for people to be clear that when we talk about convictions and allowing a judge to review a conviction, a part of what you're asking a judge to review is the information that surrounds whatever that plea bargain was, right? And were there forces? Is there an explanation of what happened that a judge can assess in addition to all the other circumstances? So that's a part, when we talk about second look, it is allowing a judge who is cognizant, right, of who will be appealed to be asked to be cognizant of the forces that might have contributed to this conviction, and allowing the judge an opportunity to make an assessment as to whether that sentence should be modified. This doesn't mean that a person automatically gets put out of jail. It just allows us to look and make an assessment. And I think all of us, right? So this goes back to what I was saying about the use, because typically when people say victims, the image is white women, right? So, and I should have said this earlier, Black victims were present primarily in the hearing that I'm referring to. And so we're going back to the idea of those who have been victimized by violent crime. What I just laid out is in some ways a different issue entirely, right? What I just laid out was allowing a judge to assess whether or not this conviction was even legitimate, to assess whether this conviction had more to do with the leverage a prosecutor had over me, as opposed to whether I did the thing or not, right? So it is for a judge to be able to make that assessment, right? And in a judge who makes the assessment that this person did this, and this person hasn't made the sufficient changes in their life to demonstrate that they have done enough time and should be let out. Like, these are all the things that a judge would be at liberty to make those kind of assessments, right? And so that's one aspect of it that's important to be clear about, right? So that's one. And then the other thing is that many Black victims of violence, one of the things that drives their willingness in many respects to support, or to oppose rather, things like second look at, is that the reality that Black victims of homicide and their cases are twice as likely to not be solved than white victims of homicide. So many of those families, those Black families that have been victimized by homicide, are dissatisfied with the fact that many of them feel like no one gets punished, right, for the harm done to their family member. That is a legitimate concern. That concern is not dealt with by opposing the Second Look Act. That is actually addressed by having a police force that is composed of more people who actually care about Black life. Because if we're honest, there are a lot of people that work in majority Black settings, places like Baltimore City, that have internalized these notions of inherent inferiority, that don't have much regard for the life of Black folks. And so a young brother, 25-year-old brother who was killed is not that big of a thing to them, because they perceive us as animals anyway, right? It reminds me of a Sylvia Wynter essay she wrote after the 92 rebellion in LA, after the acquittal of Rodney King. And she actually describes a phrase that law enforcement officers would use at the scene of a homicide. The phrase was "no humans involved," right? NHI was the acronym they would say on the radios, which stood for no humans involved, which to me is a tremendous metaphor for the way that law enforcement in particular, and our society in general, regards Black life in places like Baltimore City. of the kind of person I mentioned. 25-year-old black man, working class, no, no one cares. And that is the reason that for a lot of families, those cases don't get solved. And opposing a second look at doesn't change that, right? Again, what a second look at does is provide a judge the opportunity to assess a person's case. And so what I want to end on is that, and the reason why I wanted to end with that, and talking about that op-ed, is that Black suffering is often weaponized in ways, particularly in that instance, right? Where you had Scott Schellenberger saying he doesn't want to have to keep telling these families that they got to relive the traumatizing event, as if his political agenda is aligned with addressing the material conditions of Black people. And all of the things I mentioned, Schellenberger is in opposition to. It's the Baltimore County State's Attorney. Policies, all of them, which participate in the denigration of Black people, that participate in the way that the criminal justice system dehumanizes Black people, particularly working class Black people. So to be able to stand there and say, in solidarity with the pain of these Black families, to oppose a second look at it, it's similar to the way that when we talk about violent crime, and going back to what Senator Folden said in his response to Senator Sitnor and the traffic stops bill, that if we're talking about addressing violent crime and public safety, it is not law enforcement and it is not punishment that's going to be the primary way to address violence in our community. And that criminal justice reform and making it so that our community doesn't deal with the level of dehumanization that we deal with as a result of those systems. Public safety is used as a political wedge, because what they don't want to say, but what the actual belief is that the constituencies that a Schellenberger, that a state's attorney, Howard County Rich Gibson, that, and Ivan Bates in terms of the mandate that he was elected on, the Hartford County Sheriff, the state's attorney in Montgomery County, these are folks for whom their constituency is energized, right? Their constituency identifies with policies that are harsher on Black people. That for them to say, we are making sure that we're locking people up. They don't got to say Black people, right? But all of the societal propaganda fills that in for you. And they know that they are in constituencies that are energized politically by being able to say, we are legislating in ways, we're advocating in ways that track more people who are potential bad guys into the criminal justice system. And unfortunately, those potential bad guys happen to be working class Black people who live in communities that are over policed, right? And live in communities that have been ravaged by the system of white supremacy. And so it's important that when you hear people who are opposed to certain reforms that we advocate and others advocate, it's important that you're clear that the basis of their opposition has to do with the fact that that those reforms that are seeking to address the concerns that are dealing Black people, not dehumanization, that the opposition is based on the fact that there's a lack of regard for and a rendering invisible the day-to-day oppression that now has empirical evidence, whether it's the 2016 DOJ report, the 2021 Steptoe report about Baltimore City Police, the Graham report about Prince George's County Police, the Restoring Trust in Policing Commission from 2020 that the state of Maryland's legislature commissioned. All of these studies provide the empirical information needed to substantiate the fact that our community is brutalized by these systems. And so when people raise public safety as a rationale for not engaging policies that reduce this harm, that is an example of the way that white supremacy operates. That it operates in the way that public safety, that notions of Black people being inherently criminal, become a weapon that is used to make it make sense to people to not support efforts that will reduce the harm done to our community by the criminal justice system. And so that is a ever-present dynamic in dealing with conversations that that talk about Black people and the impact the system has on us, it's important that we're clear about that, and that is something that we're going to hear over and over and over again in the Maryland General Assembly. So that in essence is our legislative update for the evening. As I mentioned, we're gonna put up information about when these bills are going to be heard. One of the things I just want to emphasize is that as it relates to LBS and the work that we do, we're very fortunate to be an independent Black political organization that can bring this level of analysis to the community, to those who support the work that we're doing. My hope is that if you support the work that we're able to do, if you support our ability to be able to unapologetically advocate for Black people, and be able to provide this analysis, that you become sustainers to support us by contributing, once a month. You can sign up on our website at lbsbaltimore.com or sign up to our listserv, to our email listserv. So we put out action alerts. We actually put out an action alert, as I mentioned, around the auto charging bill that I mentioned earlier in the podcast. And so it makes a big difference when folks reach out to their legislator and, tell them to support the efforts that we, explain to people are important. Like, that makes a big difference in terms of our legislative advocacy. So, if you support, what we talked about this evening, the work that we're doing, please join our listserv, reach out to your legislator, so we can increase the pressure to overcome the system of white supremacy that, unfortunately, things that should be easy. Like, a lot of these policies are things that really should be no-brainers. But unfortunately, they're difficult because we live in a society that sees Black folks as inherently criminal, and therefore makes it so that these kind of policies are seen as making people unsafe, as opposed to addressing the dehumanization that happens to Black people. And so sending those emails is a huge help and the leverage that we need to advocate in the manner in which we advocate. So stay tuned, continue to watch out in our social media, LBS Baltimore, all your relevant social media. Sign up for our email list, watch our social media, and stay tuned. We're going to continue to bring information to the community so you can help us in our advocacy. And so with that, thank you very much. See you next time.